Welcome. We will be beginning shortly here. It is 11:30. See that, Tasha? It's 11:30.
Got it. Looks like we're still having a few people join us. We'll wait a couple minutes.
So I'm really excited about this topic today. Tasha and I have been working on it, and super important stuff. I'm so glad you guys are listening to this. You will not be disappointed. These are fantastic pointers, and there's a lot of stuff in here that when we talk to people, even other estate planning lawyers are like, oh my goodness, yeah, I forgot about that. Or yeah, that is really important. Or yeah, that came up a couple of years ago. So we're really important. We're really excited about today's topic. Well, you want to get started, Tasha?
Yeah, let's go.
Let's do it.
All right, here we go. Well, thank you for joining us. You're here. We're talking about fix it now, the hidden traps and outdated trust. So that means that if you're here, you probably already have a plan in place. You have a trust, and it's really important to have a plan, but then your plan has to be successful. So we're going to be taking you through kind of our top 5 hidden traps in outdated trust. I'm Tasha John. I'm an attorney here at Cunningham Legal, and joining me is the founder of Cunningham Legal, Mr. Jim Cunningham. So,
hey, Tasha, thanks. I was saying, this is so important because there are hidden traps. And I will tell you, I heard this recently. It's kind of easy to know if something's done right. Like you can look at it and go, yeah, that's my name. Those are my kids. Yeah, my house is in my trust. Or, oh, no, it's not. But it really takes an expert to know when something is wrong. And so we're going to kind of flip it a little bit and look at situations where things have gone wrong and then show you ways to fix that. And it's so important because, frankly, what is more important than your legacy and providing for the people you love? So, I mean, I can't think of anything more important. So let's get started, Tasha.
Yeah. So I'm going to first start just with putting this disclaimer up there because Jim and I, we're attorneys and we're here providing so much valuable information, but this is not legal advice. We don't want you to run out and do something. You should be seeking professionals, and we will offer that opportunity to meet with me or Jim one-on-one for a free consultation after this. And when we meet with you for that consultation, that's going to be legal advice because it's specific to you. Just a few housekeeping rules here. If you have any questions as we go along, there is a Q&A bubble up there on your tab. Go ahead and you can type in those questions, and we're going to try to remember to look at those and answer them for you. And at the end of this webinar, we'll have a chance also to readdress that if some more questions have popped up while we're going through here.
Yeah, and it's really important that Q&A, please don't put a lot of personal stuff on there. It's okay to ask hypotheticals or, don't kind of anonymize it because this is shared. Everyone's going to see this. Yeah. I think there's some functionality where you can just go to the panelists, but if it gets too deep, that's where we typically recommend you talk one-on-one with the lawyer. But you can use that or the chat. The Q&A is a little bit better because there's a way we can answer the questions and tick them off. But you can also put them in the chat if you're a little technically challenged when it comes to Zoom, like my parents. So they do use Zoom.
Yeah.
So let's start with this. What gets you into trouble? So what gets us into trouble? Well, there's what we know, and that's the yellow. And that's pretty easy, right? We know what we know. Then there's the blue, and there's what you don't know. So there's what we know, okay, and then I know what I don't know, but there's a much bigger portion, which is you don't know what you don't know. That sort of what you don't know is really what gets you into trouble, and that's kind of what we're going to be focusing on today.
Mm-hmm. Yeah. All right, so we're going to go ahead and look at that guy with the trap. We're going to talk about the top 5 hidden traps in outdated trusts. So without further ado, we're going to move on to number 5, out experience.
It's kind of like an out-of-body experience.
Yeah.
But it's an out-of-bucket. So this is not when you kick the bucket, but there's an analogy. I won't go too far with it. But you can think of a living trust as a bucket. So you can hold on to your stuff in your hands. I've got my house, my bank account, my stocks, my bonds. You can hold on to those in your hands, or you can create a living trust. And as you know, the big benefit of a living trust is it makes it much easier, not totally easy, but it makes it much easier on the people that you love and the people who are going to handle your affairs if you get sick, become incapacitated, and certainly when you pass away. But what's very, very important is when you create this bucket, which is like a living trust. So the living trust is the bucket. Now, when you create a living trust, you create this bucket and you put all your stuff in it and you hold on to the handle right here. You're holding on to that. But there's stuff that falls out of the bucket. And I would say the biggest thing that we're going to cover here is when you refinance a house or you get a mortgage on a piece of property, your home, investment property, many times the bank will make you take that property out of the trust. And I can tell you, last year we did about 50 court petitions on estates that we were handling where we had to go to court to put the property back into the trust after the client died. So it's very important. So Tasha, you want to walk through the basics of a living trust and what we're talking about?
Right, and I think so, you've created essentially this great bucket like Jim had referred to, this trust, and you're the creators, right? The grantors, typically we call it. And you've hopefully retitled your assets into the name of that trust and placed your bank accounts and brokerage accounts and your home, and everything's been titled over there. Hopefully that was initially done for you, but as you can imagine, you've gone through life and there's a misconception. You put that trust, in a drawer somewhere and it's going to take care of you forever. And meanwhile, your life is changing. You have different bank accounts. You closed that, you moved that asset, you purchased another piece of property. And so I can tell you that there's so many times that when a life circumstance has occurred, either incapacity or you've passed away, many times there's things left out of your bucket. And what does that mean for you if that happens? I mean, the whole purpose was to avoid probate. You'll find out here today there's a lot more behind a trust than just that. But what happens is you still have to go to court. It's not going to keep you out of having to go through the court system if your stuff is not in your bucket. And this is unfortunate, just how a lot of times these plans are failing, is that the assets are sitting outside and we have to go to court. We have to try to grab them and place them back over into that trust to make sure that everything you put forth your plan is going to be successful. And
yeah, and Tasha, you're so right, because this, what we call, now I think you get it, out of bucket experience, not a good experience, okay? An out of bucket experience when somebody dies, that means you have to go typically to probate court to get that asset inside of the bucket. And that happens, and this is one of these things, you don't know what you don't know. So you may not really give it a whole lot of thought. Oh, I need to refinance my house. Okay, I'm going to pull that property out of my trust. And then, you refinance and your payment goes down, or you get cash out or whatever you're doing. And then it never gets back in the trust. So very, very important. Pay attention, not only the house, but the stocks, bonds, mutual funds. A lot of financial advisors will change the company that they work with. So they might go from company A to company B. Well, all those, they typically, you might see your statements change. Those statements, you need to make sure that those assets that were in the trust before your advisor moved, what we call a broker dealer, if they move to a new institution to work for, basically, make sure those are in the trust as well. And that's not, it's not hard, but you do have to pay attention to it.
Oh, sure. And sometimes, it seems difficult. Like I have some clients that purchase property out of state, and they it would seem difficult during the process to have to bring up the trust, or maybe they forgot, or the escrow company told them, oh, you handle it on the back end. And now they've got a piece of property in another state that has not been placed into their trust. And that's going to cause problems in a court proceeding in that state, right? And so, boy, it really is significant. You have to make sure your trust is following you through your life, and you're placing everything constantly in that bucket. It's pointing there, it's named in the name of the trust, so that way it can be successful when something happens. And so when talking about your trust, just in general, I'll tell you, because your life is changing and so are your loved ones, one of the big elements within your trust is who is that trustee that's going to step forward, and make big decisions for you fiscally if something happens. And so there's a lot of this. Well, who has the power? Who's your trustees that are going to step forward and make those big decisions for you? And I'm telling you that we see a lot of fighting between siblings over power, even though things might be going equally to them, right? It's about, well, who gets to control it? Why mom and dad have a lack of capacity. So boy, those changes in your life, when it comes to your trust, you've got to take another look at that. See who'd you put in charge. Maybe your loved ones have moved away. Who lives closer right now? Does that have, is that a large consideration for you if your health is declining? Do they still get along? I mean, right? Maybe it's been so long, they've been married and now the spouse has come into play and there's just a lot of just siblings not really being able to handle this together. So your trustee choice is something that you have to, I think, constantly take a look at and make sure that you have the right people to step forward and to take care of you, fiscally. Anything to add to that, Jim?
No, I mean, it's a great question. The other thing too is sometimes, it leads right into this. A lot
Yeah.
of people, so I will tell you, one of the biggest misconceptions about estate planning, and when somebody passes away or they become incapacitated, many people think, oh, I did a living trust. I don't need a lawyer involved at all. I will tell you folks, if you don't get a lawyer involved, you may end up paying a lot more in taxes. Okay. So one of the key things you need to think about is when somebody dies, that's a taxable event. Okay. And we're not talking death tax. We're not talking estate tax. We're talking income tax, capital gains tax. Those are the two big ones. You want to make sure that you engage a lawyer to make sure that you don't expose yourself and your beneficiaries, quite frankly, the other people who are inheriting, to paying more tax, because they're not going to be happy with that. And one of the other things you need to bear in mind is that when that trustee becomes trustee of your living trust, that successor trustee, they have 100% personal liability, 100% personal liability for everything they do and everything they don't do that they should have done. And so I'm telling you folks, you really do need the involvement of a lawyer from the get-go when it comes to administering a trust, especially if there's any potential for conflict. But frankly, these are written in legalese. Even our estate plans are written in legalese, right? They all are. They're really thick and dense, right?
Yeah.
And you do need help with this because there is a process to go through. We do have upcoming virtual workshops on what happens when someone dies, and I encourage you to attend those. That's a really good idea if you'd like to know.
Yeah, and I think everyone viewing this, a trustee just went, what?
Well,
Oh no, I'm personally responsible. Yeah, so those, and part of that is they don't have to know they're not going to know what to do. It's a complicated trust to read, and they have so many obligations through the probate code. But that's why we're here. That's why they come to attorneys to advise them, and it can help a little bit if there's problems with siblings, especially during that time period a parent is incapacitated. And that trustee just needs some guidance, really, protection and guidance. And that's what those attorneys are offering to those trustees and guiding them through that process. So really important, again, that top number 5 hidden trap, that you're actually avoiding probate. You're being successful in accomplishing your goals, and you've taken a look at that document and things are titled properly. You've got the right power people in place to step forward. So I'll go forward to, it's our hidden trap number 4, because Uncle Sam always wants more taxes here. Failed structure. Oh my goodness, this is a big one. I review hundreds of trusts a year of already created, that were created during a time period that the structure revolved around what was happening in the laws, in the tax laws. And this is often how these estate plans are failing. This is a hidden trap. Not a single one of these clients I meet with read through there and saw that this was something that they had. It's a structure embedded into that legalese language that they're just unaware of. And so we're going to talk a little bit about what that looks like in a trust. And what it revolves around is something called the federal estate tax, or we refer to it often as a death tax. And the rules with a death tax is that essentially the federal government gives you a certain amount of money you're allowed to die with tax-free. And once you reach over that amount, you're going to pay like 40% over to the federal government. And this is the current laws of today of 2020. You each get $11.58 million to die with tax-free. And with married couples, you each get it. So you've got double the death coupon, we call it. You've got a death coupon. Not too many people are reaching that threshold right now, right? They're not over that.
Yeah, I think it's actually like 99.99% of estates are under that $11,580,000 threshold. So, and that threshold used to be, Tasha, what?
Oh my goodness. Yeah, it's changed significantly. So this is one of the largest changes, is that we've progressively seen it get higher and higher, but it's not that long ago. It was 5 million, it was 1 million, it was 600,000.
Right.
Met with someone today during a time period, it was $1 million that you could die with tax-free. And so you can imagine that there was a time period where everybody was worried about the death tax and how do we avoid it and what's the strategies, especially when it comes to us, estate planning attorneys, and writing something into the structure of your trust. And now we've mentioned here California as a state, we do not have a death tax or an inheritance tax. We got rid of those in the late 70s. We say that, but you know, California needs money. Okay, so you just never know. I mean, there's been talk, of course, of putting it back on the ballot. You'd have to vote for it to bring back the death tax to California. This is kind of the proposal we saw in 2019. Anything over 3.5 would end up paying a death tax to the state of California. But currently, it's your only tax benefit of living in California is that we do not have this. And many states sitting around us, well, they do. And it can still apply to you. And it's important for you to be discussing with your attorneys, where do I own property? Where do I think I might move? You know, and is it going to affect the structure of my trust? Okay.
Yeah, that's so important. I was speaking with, over the weekend, I was speaking with a friend up in Portland, and it reminded me that Oregon has a death tax.
Yeah.
So when your assets go over $1 million, it's up to 16%. Now,
Yeah.
Oregon's kind of cool because you don't have to pay sales tax and you don't have to pump your own gas. But if you have more than $1 million in assets, you pay a death tax and a state tax. Now, you might think to yourself, well, I'm a California resident. Why do I care? Well, a lot of our clients, especially in Northern California, have real estate in Oregon. They might have a beach house. They might have a vacation home. It's very common for people to divide their time between Oregon and California. And something you need to know is if you own a home in Oregon, they're going to include all of your other property, wherever it is, and put the Oregon property on top. And they're going to say you owe us up to 16%. So meaning if you have $1 million estate in California and $500,000 home in Oregon, they're going to count that $1 million California property against what the tax is going to be in Oregon, so that they say, oh, you died with $1.5 million estate and 500,000 was in Oregon. You're going to owe some money, some death tax to the state of Oregon. There are some ways around that, but bear in mind, when you own property in other states, you need to let your attorney know. And I mean, most of you guys, I can see a list of people. Most of these people are our clients. Please let us know if you own property out of state. Very, very important.
Absolutely. Yeah. Or if you plan to move to another state, so we'll have to talk about that too. So what happened is, you know, when the tax laws were different, it meant there was a different structure within these trusts. And what you will see is that there was this AB trust was really common. I mean, I had an AB trust, you know, that I had to change over, and it's not, I had very little wealth. And so it's one of those things that most people had. As a married couple, they created this type of structure, and it was essentially to try to save on death taxes, because like we talked about, everybody was being subject to it. At one point, it was a 70% tax. It was really, really high. So what the actual trust says is that while you're both still alive and well, and you know everything is great, you have full control over everything in the trust, you would never know you had it. But then as soon as one spouse passes away, two new buckets are created. Essentially, your entire estate is going to be separated into what's called an A trust and a B trust. All right. The A, half of the property put into the A trust, well, that's for the alive spouse. That's the surviving spouse's share. It's going to sit in that A trust. They get full access to it. They can make changes to it. But the other half is placed over in that B trust. That was the buried spouse's half. And it was meant to be preserved. So it's an irrevocable trust. You can't make changes to it. And there's usually a lot of restriction on that surviving spouse being able to dip into that B trust to use for themselves. They usually have to go through their own trust first. This was great planning for the death tax. It allowed that B trust to grow and grow and grow, and the assets in there growing, and keep it out of the estate, all that growth. So we were saving a lot in death taxes. But what happens now is that when the second spouse passes away, right, they had all this, remember, they had to do a separation. As soon as one spouse died, get a tax ID, do accountings for that B trust, lots of restriction. And then eventually they pass away. And when the assets are distributed out, everything coming out of that B trust is actually going to have a negative tax problem. There's going to be some capital gains taxes that are now going to be an issue for everything that goes into the B trust. And so to explain that just a little bit, it's called a step up in basis. And Jim, I don't know if you want to explain it, but essentially all your assets have a basis, right? Your properties and your stock. And if they've been going up over time, right, and going higher and higher and higher, when that first spouse passed away right here, all of that community property assets, it got a step up in basis to those date of death values. Lots of opportunities there. You should be working with your attorneys on if you have some choices to make. But if you hold on to all your property and it continues to rise in value, ordinarily when that second spouse passes away, everything in the estate will get a second step up in basis, so the heirs could sell everything, liquidize whatever they needed to do, and they don't pay any capital gains taxes. Well, that second step up in basis we're talking about, you don't get that for everything sitting in that B trust.
Yeah, let me give you an example.
Yeah.
So let's say in this example here where you see the wallet above the A and the B, let's say a married couple, when one spouse dies, they have 2 apartment buildings and they're each worth $1 million. So a $2 million estate, they each have 2 apartment buildings worth $1 million. One apartment building goes into the A trust. The other $1 million apartment building goes into the B trust. So we have $1 million apartment building in the A trust and $1 million apartment building in the B trust. Fast forward 20 years, whatever the time period is, those apartment buildings have now doubled in value. Now they're each worth $2 million. So on the A side, that property is worth $2 million. And on the B side, that apartment has also gone up to $2 million. Well, when the kids inherit, the kids can sell the $2 million apartment building out of the A trust and not pay any capital gains taxes. But when it comes to the B trust, when that property is distributed to the kids, and then the kids turn around and sell the property, they're going to pay $371,000 in capital gains tax, because your basis is the date of death value when the first spouse died on the B trust minus depreciation. So for those of you who know about that, but on a high level, that $1 million property that's now gone up to $2 million, when the kids sell it, they're going to have to pay capital gains tax. Federal currently is 20. The Biden tax proposal actually increases capital gains taxes, but currently the federal level's 20 plus 13.3% state plus 3.8% net investment income tax. That's 37.1%. That's where I get the $371,000 figure from. We have been successful in taking families back into probate court after one spouse has died. So after one spouse has died, and terminating the B trust, so that when the kids inherit the 2 apartment buildings, there are no capital gains taxes. That's kind of cool. But if you're both alive, if the husband and wife or the spouses are alive, you can actually do a restatement. You can get rid of the B trust. This is what Tasha did. It's what I did with my own estate plan, because I used to have a B trust, right? But we did what's called a restatement, and we amended our trust and got out of that.
Yeah, and boy, hidden trap is absolutely what to call this, because I can't tell you how many times I get a surviving spouse in here ready to make some changes, and we open up that document and it was an AB trust, and it's a mandatory funding. You have to do this or you take it to court to get rid of it. So it's one of those hidden traps that you have to keep in mind, that how attorneys are drafting your trust is really dependent upon tax laws. I know that's just hard to believe. So again, you can get rid of it. You can restate it. So important to do while you're both still living and well. Otherwise, it's something we're going to have to fix on the back end. And that's just a lot of money and time that could have been avoided. So got to keep up with those changes. The changes in the tax laws, so important that you avoid this hidden trap. All right, moving on to hidden trap number 3, not protecting your beneficiaries. So, I mean, who are your beneficiaries? I have 3 children. My children are quite young. They're 12, 10, and 7. And I know, Jim, you've got 3 as well.
Yeah, but they're in their 20s, and they kind of look like, they actually look like the people
like that.
Yeah, right.
Yeah, so sometimes it means protecting them from themselves, like
right.
maybe like someone like this, 50% of people, they tend to spend their inheritance right away, right? It's not theirs, they didn't know it.
And let me explain to you, the reason we talk about this is this comes from handling estates after someone dies. So our firm has a lot of experience. In fact, we are in terms of who has the most experience, we are really up there. We handle about 300 or 400 trust administrations a year. Now, what that means is someone's passed away. or they become sick, and we're helping them. But we handle about 300 to 400 a year. And we see a lot of trusts that we didn't write, because people come to us, right? They say, hey, I saw you guys, you didn't do my estate plan, but gee, like they say, my brother is in the middle of a divorce, or my brother is in the middle of bankruptcy, or my sister really isn't that good with money and she's going to blow it, and then she's going to come back to us for more money. So I will say that a lot of good lawyers simply don't think this through enough. And certainly if they're not an expert lawyer, they might just, say, give it to the kids and hope for the best, and I'm sure everything will be fine. You have a great family, which is all true, but let's get into why protecting your beneficiaries is a good consideration, a good thing to think about.
Yeah, and some of it does have to do with age, right? Like you're considering what age is really appropriate for someone to come into inheritance. And so that's going to make a difference. And so you definitely wouldn't want to give it to them called outright, free of trust. It just is like a check is written and it comes into their pocket at age 18, right? And probably not the best age to come into a lot of money, and you'd want it to be somewhat protected. But even for those really responsible loved ones, you are going to want to be talking about how to maybe protect them from those outside third parties. And how we do that is through something called a continuing trust. So again, protecting them from themselves, that's one of those hidden traps, but also there's going to be, protecting them from those third parties. So, and what we're talking about is anytime that there's assets out there, there's money, there's always going to be a risk, okay, involved with that. And we're talking about creditors, all right? So it could be lawsuits, it could be our loved ones are in certain professions that tend to get sued more than others, right? Maybe we want to protect the inheritance from that. And it could be predators, people in their life that make them really susceptible to influence, that could come out of the woodworks and have these great plans with the inheritance, maybe not so great for our loved ones. But the number one, cause of a loss of inheritance is through divorce. And so, 50% divorce rate still in the United States. So what we're talking about is, wouldn't it be nice to maybe allow them to inherit into a separate pot from their spouse, where we can put some protective features around it, some asset protection features, so that it cannot be taken in a divorce. It can be held separately, that we can protect it from those creditors. And we do that through something called a continuing trust. I see there's a question up, and so do you, this is in regards to going back to that B trust planning we talked about.
Yeah, I'm looking this up. The question is from an anonymous attendee: has Biden's plan mentioned anything about lowering the gift tax exemption? In other words, will it roll things back enough to reintroduce the need to have a B trust again if he gets elected? So this is, and I don't know if we're going to be talking specifically about this, but something happened in 2011, and it's called portability. And let me explain what that means. Is it used to be we had to do an AB trust so that on the death of the first spouse, we could conserve that coupon amount, whether it's 600,000 or a million or 11 million and change, so we could conserve the ability to leave that amount of money tax-free. Well, in 2011, there was a change in the law, and it said that a spouse can inherit that coupon and obviate the need or eliminate the need for a B trust in theory. And again, it depends on circumstances. But I will tell you, in certain circumstances, we do use B trusts in our practice. We do them in a very sophisticated way that is tax efficient. That generally was not the case before. But Biden's proposal is to drop the exemption to $3.5 million. So if you're married, you can double up for $7 million. So if you were, for example, if you were 60 and had a $6 million estate, and you think your estate's going to increase over time, and you knew one spouse was going to die, right? Earlier, I'm just giving a hypothetical, you might consider a B trust in that context. But there would be added functionality to the B trust, so that if the estate laws were to go back and give you a high exemption again, you could include that B trust in, I'm going to use a technical term, include the B trust in the surviving spouse's estate to get an adjusted cost basis again. So if you understood that, kudos to you. But the bottom line is, we have to pay a lot more attention to tax law now than we did before, because it's much more nuanced and much more sophisticated than it had been in the past. So the short answer to your question is, would you have to have a B trust again? Generally no, but maybe yes, and it really depends on your situation.
Yeah, and even for those, like Jim said, that we are planning that are over that amount now, we have more flexible ways within that planning structure is what Jim's talking about, that to essentially be able to post-death determine what are the laws and do we need that B trust. So a little bit more flexibility in the plan than a standard A, B, and that's it, and that's all you get.
Yeah, and here's really what's going on is the current estate tax rate is 40%. The current capital gains tax rate for California residents is 37.1%. So there's really, it's not a whole lot of difference. The only issue is estate tax must be paid 9 months after death, and capital gains tax is made only when there's a sale of property, or, and this is very important, and this is enough, we're not getting into the weeds this much, but if you distribute property from a B trust and don't terminate it, the distribution of that property causes a capital gain. And that's very, very important to understand. So it's really easy, if you do not get good professional advice, to frankly really screw things up for yourself and for your siblings, typically the other beneficiaries in the trust, and they will not be happy with you. And frankly, you're legally responsible for those damages.
Yeah, yeah.
If real estate is community property with survivorship, will that help? Yeah, I mean, because you get an adjusted cost basis. Absolutely. That's something. Community property with right of survivorship is good in some contexts. The problem, though, is when the survivor dies, you have to probate that asset. So what that says is, you know, Jim and Lori, my wife, we hold the property as community property with right of survivorship. I die, Lori inherits the property in her name. When she dies, it's a probate asset. And the probate fees on $1 million estate, remember, are about $50,000 on $1 million estate. So they're very, very high.
Right. And I kind of think of them as two different things too. Like, even if you have something as community property with right of survivorship and you put it into the trust, you're still going to get that big step up in basis when one of you passes away. It does depend on how you had it titled prior to putting it into the trust. But it's not really helping with the B trust issue. Like, if you have a high estate, net worth, you need to be talking to an attorney to figure out what can we do about it and what's the best way to structure your trust. So
for sure,
they're not always going to coincide as to whether or not you need a B trust. So it really depends on the size of your estate. All right, so I'm coming back to our beneficiaries and planning for them and why we need to protect them from creditors and creditors' divorce, and how we do that is through a continuing trust. So I'm going to take you through a success story, giving a couple of examples. I want you to meet Vanessa. Vanessa is a client of mine who's come in and had an old trust and had some provisions in there regarding her loved ones that we need to make some changes to. She has a son who has his own business. He's doing really well, and he's really built it from the ground up and been wildly successful. But as we're talking about it, initially in her trust, it was the share he was receiving was coming outright free of trust, like we talked about, like just a check going to him and included in his estate. But he's really wealthy now, and his business has been sued a couple times, and he's got a spouse that likes to spend money, and that's okay. They have a lot of money; they can spend their own money. But Vanessa was really concerned. When we talked about changes she can make in her trust, this is one of those hidden traps. Boy, wouldn't it be great to allow him to have an ability to protect those assets? And so what we created for him within her estate is something called an inheritance protection trust. It's a continuing trust. Within her trust, it says that he's going to inherit into this inheritance protection trust. And now he's very responsible. It's not that we don't trust him. So he gets to be the trustee of his own trust, gets to manage the money that's in there and pull it out if he wants to, has access to it. But again, it's in its separate little box. Now he has his own box that he gets to control. And if he ever needs asset protection, if his business is getting sued or he's going through a divorce or something drastic happens in his life, he can step out of being the controller of the assets, being the trustee, put somebody else in that spot, and we've locked up that box. Now we have complete asset protection. And this is something that only Vanessa can do for her son. He can't do it for himself.
That's very important. This cannot be done after the fact. So here's mom. She's got to set it up for her son. And if she doesn't do that, her son is not going to be able to have these protections on his inheritance without doing, frankly, there is planning that's available to do that. It is very expensive. All right. So it literally is 10 times the amount of money than if Vanessa were to create this for her son.
Yeah. and again, with him being wealthy, talking about that second estate tax, boy, there's some good tax planning we can do within that trust, so that if that grows and grows and grows, there's a possibility of us keeping it as adding to his estate and creating more of an estate tax for him down the line.
And as you're Tasha, as you're talking about this, I wonder how many people who are watching this actually think about their own kids and their own kid. Like, well, I never thought that would affect my estate plan, my own kid's situation. But what we are finding is we have many clients like Vanessa who have children who are doing, frankly, very well. I mean, these are people in their 20s and their 30s. We have one client who has built, he's in his 30s, went from nothing to about $50 million in personal net worth, just being really, frankly, financially successful. And that's fantastic. But it also affects the parents' estate plan to make sure that that money's protected for their child. So very, very important.
Right, yeah. Okay, so that was what we planned for Vanessa to make it a successful plan. I'm gonna take you into another story of some of our clients. Meet Bob and Lori. They've come in to meet with us. Again, we're doing a review of their old trust, and they have 2 children. And their daughter is, things have just changed throughout her life, and she is just not a high income earner and has struggled a little bit. Her and her spouse, they have to spend a little bit more than they make to kind of make things work for them. It could be also that their marriage has been a little bit rough. So Bob and Lori are concerned about the divorce factor. Is this, we definitely would not want our inheritance to go to that ex-spouse if something was to happen. And so it needs greater protection. This is not somebody who probably can control the assets herself. And so we created a continuing trust called a dole it out trust. Just makes a lot of sense, not a legal term. It's going to be doled out to her a little bit at a time. We need greater protection so their daughter does not get to control the money. She can't be trustee. So it's got to be somebody else that is going to control this for her lifetime. And there is an expectancy here, like we think she might end up on government benefits. That's huge, when someone ends up and has, whether it's a divorce or creditors or bankruptcy or they're on public benefits, we cannot have them controlling the assets. We want to make sure that we're protecting those inherited assets. So somebody else in charge, it could be a family member, it could be something called the professional fiduciary. Maybe it's a bank or a trust company, but it could be an independent third party that's going to control this money for their daughter. And dole it out a little bit at a time. And like, it could be a stream of income every month, it could be $3,000 a month. It could be that they have to hold back, right? And not distribute anything at all. And I will tell you, this is one of those huge hidden traps I have seen in continuing trust from trust that I'm reviewing, is that oftentimes I see an automatic withdrawal right is what it's called. And it's very common a long time ago where you'd say, hey, give them a third. They have a right to withdraw a third when they're age 21 and another third when they're 27. And when they're 35, all the rest can just come out to them, right? It was kind of a way to give a little bit at certain ages. And, we as a firm are very different. We are very much looking at as an asset protection device, and that fails. That actually fails and has taken away our asset protection. Because if a creditor, if you can get to it, if you can get to it at age 21 or age 25, so can your creditors.
That's right.
It does not protect you from asset protection. So
and
it's kind of negating the purpose.
And that's such a great term. Whatever you can get to, your creditors can get to. What we've done, and Anita has a question. She says, are assets in an inheritance protection trust protected from that person's eventual prospective estate taxes? The answer is they can be. So, I mean, just if it's a yes or a no, the answer is yes. Sometimes that's a good thing to do. Sometimes it's not, because there's a capital gain. So basically, when you save estate taxes, you're typically swapping that potentially for paying capital gains taxes. Sometimes it works, sometimes it doesn't. Again, it's an individual, really an individual analysis, one-on-one with the lawyer. What we've done with other people on the inheritance protection trust, by the way, for maximum protection, it's best if that person is not the trustee. So going back to Vanessa's example where she leaves it to her son, somebody else can be the trustee, but that trust can form an LLC and the son can manage the LLC. So he's day-to-day transacting and controlling the assets, but doesn't own them. So there are a lot of, and it's probably getting too much in the weeds there, but there are a lot of ways to go on this. And we really take asset protection seriously, because I will say the number one threat is divorce. Hands down, the number one threat's divorce on an inheritance. And I can't tell you how many times we've seen kids inherit and pretty much right away, that they get a divorce, right? So that, you know, the son inherits and the daughter's been waiting for the son to inherit and get that in the joint account. Then the daughter bails, the daughter-in-law bails and gets a divorce and ends up with half the inheritance. So that's typically not what the parents want. I mean, sometimes they might want the daughter-in-law. Maybe they feel she, you know, put up with them for that long, but most people don't want their future ex-son-in-law or future ex-daughter-in-law getting a chunk of what they've taken a life to save and create.
Yeah, correct. Yeah. So Bob and Lori, again, doing a good job here. We recreated this for their daughter. They also have a son that is currently on public benefits. And so this is Phil. And anytime we have a loved one that is a child with special needs or could potentially be on public benefits or is currently on public benefits, you know, SSI, Medi-Cal, we have to be really careful how they're inheriting. And, you know, this is, you know, we knew Phil already had a special needs trust set up within their trust. All right. So, but we were, again, times have changed. And if you don't think the laws are changing regarding public benefits, they're changing all the time. Medi-Cal and what you're allowed to do, what kind of powers you can have in their documents. So within their original plan, they had a special needs trust set up, which is a type of continuing trust, right? And the type we would want to set up for anybody who's on public benefits, a child with special needs, or the potential of maybe being on public benefits. They have to have this kind of trust designed for them so they can maintain their benefits and still have access to that inheritance to make their quality of life so much better. And in their particular documents, they had an old standard that talked about allowing distributions for what we call a HEM standard. It's an acronym for health, education, maintenance, and support. And boy, the laws have changed on that. If you have that standard in a special needs trust, it's going to retroactively, it's going to, one, kick them off those benefits, and they might actually have some penalties involved. And so there are terms within a special needs trust that were placed in there and it's a flaw, and or it was, like I said, the laws are changing. And so we still need to construct this continuing trust, but we're going to make sure it's designed in a way that we're abiding by the current laws. We have the right players in place. And the more modern way of estate planning, especially when you have a continuing trust for someone who's on government benefits, is they need to have, you know, a really good trustee. We need to think that through, who's going to be controlling this for them. There's usually an advisory panel, right? We want to have a team of people that can make choices for our loved ones. And maybe a care manager, or at least an option for that trustee to hire a care manager, becomes really important. And then the last one that's really important in every trust is something called a trust protector. And I want to touch on that specifically because a trust protector is one of those, again, it's missing, and that's the hidden trap. Because times have changed, and a trust protector is a modern way of estate planning and becomes so important to make sure that your documents are going to be successful, because the laws are changing and constantly moving, and so our loved ones are changing. And, you know, it could be that the tax laws change, probate laws change. It could be we ran out of trustees and we had to stick one in there. And what the trust protector does, and usually it's your firm, so it'd be Cunningham Legal, we usually sit in our documents as the protector of the trust. We are not a trustee. We're not watching your trustee, and we will never act as a trustee. But it means your trustee, the people you chose, can come to us as the protector and say, you know, my parents are incapacitated. All the laws changed. Does this still work? Okay, you know, that California brought back the death tax. Is this still going to work for us? And instead of going to court to try to make a change, the trust protector can step in and make that change to those documents. And same with those ongoing continuing trusts, it's even more important, especially for, like I said, Phil, you know, if there's changes that have to be made for him throughout his life, because that trust is going to continue to live past his parents' lifetime, throughout his lifetime. It's got to work.
Yeah, and you know, so,
yeah, to deal
and
with
a
that.
trust protector. Here's what a trust protector is. You might be going, "What the heck's a trust protector?" A trust protector is an individual who has power over the trust, but is not the trustee. And I will tell you guys, a court always has power over a trust, always. Okay. So you may think, oh, the trustee can do whatever they want. Well, no, the trustee can't steal. That's called embezzlement. That's a crime. You will go to jail if you embezzle from a trust. It is a real crime. So you can't just take all the money and put it in your pocket. But a trust protector kind of crowds out on a lot of circumstances, crowds out the court. And why that's a good idea is you can pick your trust protector. There's a mechanism to have to control who that trust protector is. And again, as Tasha said many times, it's me, frankly, or someone in our firm. You have no control over a court. It's just not going to happen. You don't know what court you're going to end up in. You don't know who the judge is going to be. That person likely knows nothing about your family. And the nature of a court is it's an adversarial system. It's it's two people kind of duking it out. It's not more of a collaborative type project or a consensus based, which is the trust protector fills that role. Anita did have a question going back to special needs. Is dementia considered a special need? I think it can be. It's not typically what we see, but if somebody says, hey, I want to leave, my mom is in a nursing home and on Medi-Cal.
Yeah.
And it's $10,000 a month, and Medi-Cal's paying $8,000, and she's got to contribute her $2,000 a month from Social Security, and I want to leave her some money. That should be in a special needs trust, or you should think about a special needs trust because it'll kick her off Medi-Cal.
Yeah, that's a disaster waiting to happen. If you leave an outright gift to someone who it's not in a continuing trust, right, to have that protection, it's going to have a huge effect on them, and they're going to lose those benefits. So yeah, if they're on Medi-Cal, and someone that has dementia should not just be inheriting money anyways. They need somebody else to control it for them.
Well, you need a mechanism. Yeah. I mean, who's going to control it?
You've got to have somebody else controlling it. So absolutely, if they're going to be inheriting, you got to have it set up appropriately. And more than likely, if they're not currently on public benefits, there's a good chance they could qualify in the future. And so you want to prepare for that, right? Okay, so we're going to move on to our next hidden trap here. As the world turns.
All right, this is my idea. Sorry, guys. We're going back. Who remembers As the World Turns soap operas? I think they kind of went away.
I was looking, look, there's Meg Ryan on there. I can't believe it.
That's Meg Ryan, and I think John Stamos or somebody's, I don't know, pick your favorite star. It's kind of funny. I think when we were preparing for this, I think As the World Turns debuted in, I think, 1950. And it went until 2010, so 60 years, very, very, very long time. And so the idea here is the world keeps changing. So this has nothing to do with taxes. This has nothing to do with whether Joe Biden becomes our president or Donald Trump stays our president, right? This has nothing to do with the outside world, and it has everything to do with your own family soap opera, right? If I can say that in a nice way. So all the things that go on in your family. And here's the deal. When there is a change, a birth, a death, a divorce, a lawsuit, a bankruptcy, your kind of chance enters the equation. So when there's change, it becomes a chance that your estate plan will fail, at least in part, and meaning, you want to create a lasting legacy for your heirs. And something that I've been thinking about a lot recently is, wealth tends to build over generations, and there's segments of our society that the law just totally disfavored, and it's completely wrong. But there has been this long building of wealth in our society. And I think everyone who creates wealth during their lifetime, they do want to create a lasting legacy. At least our clients do. They don't want it wasted. They don't want it going to taxes. When your family situation changes, you really need to pay attention to that. And one of the problems is you may look at your estate plan and you go, well, everything looks okay. But it really does take an expert to know not when something's right, but when something's wrong, when there's a problem. And so, Tasha, you mentioned a couple of slides ago that people didn't know that an AB trust is a problem. Well, that takes an expert to look at that and go, that is potentially a real problem for your family. So whenever there is a change in your family, birth, death, divorce, marriage, and unfortunately, sometimes kids die out of order, right? We see that with clients. I'm going to lose it, but a good friend of mine, their 51-year-old daughter was just recently diagnosed with colon cancer. And, life throws you these curveballs, and sometimes things don't. When you did your estate plan 15 years ago, you couldn't imagine that your life would be like it is now, 15 years later. You need to pay attention to your estate plan, okay? Very, very important.
Yeah, and I'd say the wealth buildup has changed too. I mean, a lot of people used to have their wealth primarily in their homes. And, you know, one of the largest assets that our clients tend to have is actually in their retirement plans. And so, and more so than even in their real estate, right? I mean, they built these up, just the plan changed, right? We don't really have pensions anymore. It kind of transitioned into, we have these IRAs. And so we wanted to talk about this right now, because this is one of those big as the world turns, right? You know, this is one of those things that's really changed significantly in 2020. You know, your retirement plans, the legislation has changed with something called the Secure Act. And prior to the Secure Act, you know, you have required minimum distributions you have to start taking. It used to be 70 and a half. And the Secure Act changed a lot of things having to do with you. Like now you don't have to take those RMDs until age 72. A little bit of room there. There's going to be some better opportunities for small businesses to band together, you know, providing better 401k plans. It's an acronym, like most things. It stands for Setting Every Community Up for Retirement Enhancement. Which is what it was, you know, attempting to do. So some benefits for you while you're living, but the game changer actually had to do with your loved ones and inheriting these retirement plans, which tend to be your largest asset, right? How are we not talking about those? And so, you know, who's inheriting? What happens when they inherit? It used to be when our loved ones inherit, they could stretch out. It's called a stretch out. They could essentially use your retirement plan like their retirement plan and take a little bit every year based off of their age. And there was benefit in that because you're paying income tax slowly, a little bit at a time. And we could do a lot of planning around that. We were just doing incredible plans for people, really taking advantage of that opportunity. And the Secure Act said no more of that, no more stretch out for your loved ones. We're going to say it's a 10-year payout period, like it's going to pay out in 10 years. Meaning, okay, you don't have a required minimum distribution. You don't have to take anything year 1 or year 5, but by year 10, by golly, if you haven't taken it, we're going to make it all pay out. And guess what happens when you pay out an IRA?
Taxes.
Oh, there's a huge income
unless
tax.
It's a Roth. Unless it's a Roth.
Yeah, so that's, I mean, it's a huge change. There are some exceptions, you know, we can talk about that. There are some exceptions to being able to get that stretch for a few, you know, very small people. It could be for, sorry, I'm reading one of the questions here. So
yeah.
One of the
by the way, the answer is yes to the question, will there be a recording available? We're going to send a follow-up email. Yeah. And listen, this stuff's really dense. And a lot of people who watch this, they go, can I see that again? And they watch it again. And I know on complex stuff, I have to see it 2 or 3 times. I totally get it. So this will be it.
And we're going to hit the IRA pretty big. We have a seminar coming up this month, completely revolving around the retirement plan. So please go to our webpage and take a look at our upcoming webinars. But, you know, there are some exceptions, those that are disabled, you know, our children with special needs, boy, what some good planning opportunities, because they do get the stretch out. There's some exceptions for our minor children, you know, my 3 minor children, not for grandchildren. And then it's for those that are within 10 years of age. So a lot of planning needs to be done around these retirement plans. But how do you leave them? They're actually sitting outside of your trust. All right, they're sitting outside. You have to designate where they go through a beneficiary designation form. And you're going to have 3 choices when it comes to that form, right? So you can name the individual, right? I could just name my 3 kids, you know, a third, a third, a third. And then what happens, you know, it pays out to them, right? I mean, they have to take it in 10 years, but they get no protection from creditors, and divorce. The Supreme Court actually took that away. We enjoy lots of asset protection with our own retirement plans, but now when it passes on to someone else, there's no protection. So anybody can get to that. And that's a really big problem. And also with our individuals, what if they're not responsible? What if they cash it all out? What if, you know, they're someone with special needs that should not be managing it and needs to get that stretch out? So that's not, you know, usually it's not going to be the best choice, and it's unlikely to get tax bracket management. So again, we're back to taxes, because we want to be able to think about reducing the income taxes, right, of our loved ones. What tax bracket are they in if they're inheriting? Are they very wealthy, like my client's son who has his own business? That will add a huge amount of income tax into his own life if, you know, we leave it to him. So are there solutions for that? There absolutely are. I'm going to talk a little bit about it. So not the best plan there. Oh, this mistake we see all the time. Someone's named their living trust on that beneficiary designation form. to inherit, the retirement plan drops into the trust. Oh boy, it most of the time results in a 5-year payout instead of now the 10-year. I mean, even it was worse before, but now it's 5 years. Like, it's usually that they're going to force it to pay out, and that's what the custodians are doing. And boy, would it be a fight to try to make them to do anything else. And no protection also within that, falling into that trust. So we have a lot of problems with it falling into the living trust. That's not a good solution. And so the solution in this sometimes is creation of another trust just for your retirement plans. We call it an IRA inheritance trust. And it's meant to really only hold those retirement plans. And so the beneficiary designation form will now say it goes to my IRA inheritance trust. And by doing that, we get a lot of opportunities for tax bracket management. And most of the time we take it out of California. We name a trustee over in the state of Nevada, because sometimes it's better to move it to a state that's a little bit more tax friendly. And we're going to have more options to maybe avoid those income tax. And then we get back the protection we were missing, right, from creditors, and divorce. So a lot of opportunities, again, individualized. We can't give one blanket advice to anybody. It depends on who's receiving the IRA, what's the amount, what's their income tax bracket. Are they in a particular situation that we have to think and structure a little bit differently for them?
Yeah, and I will tell you, Tasha is well-versed in this. Very, very few estate planning lawyers, and I know because I talked to them, very few estate planning lawyers truly understand this. I mean, I talk to a lot of lawyers, and I go to a lot, well, used to, when we actually interacted with other human beings other than by Zoom. When I would go to live events, very few lawyers understand this. And it kind of, I feel like sometimes like I beat my head against the wall, because this is such an incredible opportunity. If you have a $500,000 IRA when you pass away, $500,000 IRA, I mean, it's a lot of money, but it's not that big of an IRA. A lot of our clients have a $500,000 IRA. In 10 years, that's going to become $1 million. What the current law says is in 10 years, the beneficiary, the beneficiary needs to get that money. If you live in California and you add $1 million to your income in a year, that's $130,000 in state income tax. If you put that IRA in Nevada in an IRA inheritance trust, at least you can defer, under current law, you can defer that $130,000 tax bill. And there are a series of cases working through the Supreme Court right now that stand for the proposition that $130,000 tax bill can be totally avoided. So I'm very hopeful. I think that's the direction that the cases are going. But this is a very, very serious state income tax issue. Something else to be aware of: if you're a California resident and you're the trustee of a Nevada trust, that Nevada trust is going to have to pay California state income tax. So very, very important, if you're named as a trustee, before you say, yeah, I'll do it, you need to pay attention to the tax consequence on that. And then we have a question from Mary, and hey, Manley and Mary, Mara, how you doing? Are there any gotchas if you intend to leave the majority of your estate to charitable causes of a donor advised fund? There are some gotchas that can be particularly tricky. That's, I think, a one-on-one. If you're going to leave some assets to a donor advised fund, what that is in a community foundation, there are community foundations all across the United States. You can create a donor advised fund where if it's December 31 and you say, I want to give to charity, but I don't know which charity, you put 10,000, I'm just making up a number, you put 10,000 in a donor advised fund, you take a deduction this year, but the money isn't actually spent until, later. You're better off giving your zero basis assets. What I mean is you're better off giving your IRAs and annuities and things like that to the charity, because you get an income tax deduction and save on income taxes.
And I think that might be what they're saying is if you're going to provide for charities on your beneficiary designation form, if you've named a charitable organization, it can be an advantage to.
Yeah, and you got to be careful with that though, because if you name a charity as a beneficiary of an IRA, it can mess up the other beneficiary's ability to stretch the IRA out over 10 years if all the time limits or the you got to do stuff within a certain period of time.
You got to watch
it's kind of the tip of the iceberg. But Manley, I think that's something if you want to talk one-on-one, we can go over that with you.
Okay, asset and income protection. We're kind of just throwing this in there because, I mean, who here wants to reduce their income taxes or have like asset protection, right?
Yeah, and if you want to pay less taxes, or you want to protect your assets, just check in with us, and we can help you with that.
There's a lot of different tools essentially that attorneys can use, and you'll see a couple things listed on here. Charities have a lot to do with that planning. If you're someone that's charitably minded, then we can talk about that to help eliminate some of those capital gains taxes. And but these are type of strategies that we can speak about if you come in to talk to us. Okay, we're moving on to hidden trap number 1. Planning has outlived its purpose.
What are we talking about here?
So, I mean, 10 or 20 years ago, you could have put together some kind of planning that really just doesn't make sense now. And we see this a lot when it comes to life insurance.
Yeah. So here, most people, I think I got my first life insurance policy. We had our son. I might've gotten it before we had our son. I think I became an attorney at 25, and I bought a permanent insurance policy at age 26. I think I was 26. Well, my wife and I are in the process of changing that permanent policy to something else, because why do you get life insurance? And here, if you look at this little kind of pyramid here, life insurance primarily is to replace income. Sometimes it's used to pay the mortgage, so if you have a premature death, pay for the kid's education, giving money, funeral, and debts. Many of our clients don't need the income replacement anymore because they're not working. They don't have a mortgage. They put their kids through school. They've prepaid their funeral, and they don't have any debts, but they still have this life insurance policy. Mm-hmm. So in this sense, this is what I'm talking about, is the planning has outlived its purpose. My in-laws, my mother-in-law recently passed away, and my wife was the primary caregiver for her mother. Her mom was in an institutional setting. They did not have long-term care insurance. The cost of their care was about 2 times their income. So they had a pretty significant burn rate, and they did not have a lot of money. So what many of our clients are doing is they're repurposing their old life insurance policy into a long-term care policy. And here's how this works. Let's say you have a policy that has a cash value of $50,000. You can do what's called a tax-deferred exchange. It's called a 1035 exchange under the Internal Revenue Code. You can take that old policy and essentially buy a new policy of life insurance that has what is called a long-term care rider. Now, many of our clients are taking that $50,000, and you can do this with new money, by the way, but many times they're taking that existing cash value of $50,000 and they're getting $150,000 of long-term care coverage. If you never use the long-term care coverage, your kids get that $50,000. So it's a really good deal for many of our clients. And if that's something, I know my wife, she said, as soon as we can get long-term care insurance, I want to get it. I wish my parents had it. Mm-hmm. And the long-term care benefit is not necessarily the entire cost of the care, but I know my wife said, if my parents had about $2,000 more a month, I could spend more time with my mom for the remaining time that she has on this earth. I could spend more time with her instead of doing chores, because that $2,000 would have allowed her to essentially buy more labor to do more chores. But she ended up doing a lot of chores for her mom, which she's happy to do. But the long-term care insurance really would have eased the impact. So that, I think, is, many times, and you can do this with an annuity as well. If you have an old annuity, maybe you put $100,000 in, it's worth $300,000. When your kids inherit that, $200,000 of that $300,000 is taxable as income. You can repurpose that to long-term care insurance, and then those withdrawals you don't pay tax on if it's for long-term care. So pretty cool strategy.
Yeah, you can see greatly how it changes from making sure I'm providing for my children and paying off a mortgage to, oh, now I'm thinking about long-term care. How am I going to pay for that? It's really expensive. I don't have long-term care insurance. I don't want to have to sell the house to pay for something like that. And so your plan has to have options. I mean, within your trust documents and your durable power of attorney, we need options and planning for that. But also looking at your policies, repurposing them, looking into additional policies, but then it could also be just talking with us as attorneys about you're already in that position and paying $12,000 a month. And what can I do now? It's too late for me. And so you need to come to us, and maybe there's something we can do. We do a lot of Medi-Cal planning for our clients, where we can reposition maybe your remainder of your assets to preserve them and still get you qualified. So just, it's something that life changes, right? And we have to be thinking about how are we going to now care for us in that stage of our life.
And we can connect you with the right people who know what we're talking about, because our firm doesn't sell insurance, but we can certainly connect you with the right people.
Right. Just important to be taking a look at those things, right? I mean, keep up with change, especially with things sitting like this outside of your trust. Who's named as a beneficiary to get it? You know, is it still working for you? Are the premiums going up and just, it's almost seems useless to you? We got to, you know, get you in touch with someone who can take a look at it for you. Really important. All right, so you see where we've done our top 5 hidden mistakes, and you can see what we feel the most important part of this is that you're working with the right people. You know who packed your parachute.
That's not a good parachute there. I think it's a backpack.
I don't think that's going to work out. Yeah, it matters, right? Like, who's packing that parachute? If I was ever to do something like this, I would certainly not be packing my own parachute. I never planned to do this. Very scared of heights. But it matters, right? What's in your documents? Are they working? Are you talking to an attorney and making sure on a regular basis that your plan is still working? So a little bit about Cunningham Legal and our team of attorneys. You know, it's not just one attorney. We have a whole group of attorneys that are experts in this area. You know, Jim is certified with the state bar, took a second bar exam, had to be practicing for a certain amount of years to go through those qualifications. Myself and another attorney up here, we have that LLM after our name. It's a legal master's degree specifically in this area of law and taxation. This is all we do as a firm. We do estate planning and we do trust administration, helping those loved ones.
Established in the future, what is a good resource to track on whether that might happen? The best resource is paying attention to our emails that you get, because this is a developing story. And I live in Sacramento. I live on about 20 blocks from the state capitol. So I'm telling you, I'm paying attention to this stuff. I'm right in the thick of it. All my neighbors are like lobbyists and lawyers who work for the state. So I'm out there talking to my neighbors about this stuff because they work, they're typically higher level people in the state. But that California state tax, pay attention to our webinars, pay attention to our emails, because we will be covering this. This is a developing story. It looks like it did qualify as a ballot initiative. And so it's something to really pay attention to. And given the change that is happening in our culture right now, it's happening very fast. Last year, I thought that this had no chance of passing. It wouldn't surprise me if it passed. What's your current flat fee? That's something we can talk about one-on-one, but we do for estate planning, we do offer that on a flat fee basis. Anita, very reassuring. Thank you very much. Dave, if your trust probably needs updating, would it be wise to wait until we know what our next president or party in charge? You know, that's a good question. We have an election every 4 years. I would say we would take a look at your estate plan. Some clients, I would say very rarely does it frankly matter who the president is. What matters is what the law is. And so the law right now says that on January 1 of 2026, the exemption will go down to about $6 million per person. Biden, his platform puts it at $3.5 million. So if Biden becomes president and there's Democratic House and Senate, it is possible that could get lowered to $3.5 million. I tend to think that the Fed has put so much money into the economy, trillions of dollars into the economy. Our money is awash our economy is awash with money, that we may see taxes go up to kind of pull some of that money back in from, you know, as it sort of accumulates in certain companies and individuals. I could see that being taken back in taxes. But, you know, I wouldn't wait. You know, it is one factor. But again, just call us. We can talk about it and see if you should wait. And if we think you should wait, then that's what we'll advise you to do. But it's very difficult to give a general answer.
And it really depends on your assets. I had someone today that is under $1 million for their total assets and had an ABC trust. I mean, again, kind of weighing that out. What is the probability that they would ever be subject to a death tax? Probably pretty low. So, I mean, it's, and as they're getting older, if they waited and someone passed away, well, now what? Now we have to go to court. We have, you know, I mean, it's a big mess. So it's one of those things, again, you got to keep up to date on, but I would make sure your plan right now is successful.
And right? there actually is a planning strategy that we do for married people that is a very, very flexible ABC structure. And I'm not going to get into the weeds on it, but if you're in that sort of in that sort of middle ground of, if you're married, but you've got an estate of around $5 or $6 or $7 million, should you do specialized planning? I think you should definitely contact us. But likely what would end up happening is you would end up with a highly flexible type of plan that essentially has an optional funding of a B trust, for lack of a better term. So again, thanks for sticking around so long. It looks like we've gone over time. I don't have anything else. Thank you, guys.
Thank you so much. Thank you for joining us.
Pay attention to our emails and check us out. Manly are signed up for next Tuesday's webinar. All right, Mara and Manly.
All right, well done.
Old friends. Okay.
Okay, take care. All right.